You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast, the podcast where we decode the world of patent law, one practical episode at a time. I'm your host, Adam Diament, patent attorney and partner at the law firm of Nolan Hyman in Los Angeles, California. Today's episode is called The Risk of Joint Ownership in Patents and Why It's a Trap. And no, I'm not being dramatic. Joint ownership sounds like a cooperative win-win, but legally, it's more like entering a three-legged race where one of you decides to sprint and the other sits down mid-track. Let's talk about why joint ownership of a patent can cause some serious problems and how you could avoid stepping into that trap. Here's a setup. If two or more people are listed as inventors on a patent and they don't put a written agreement in place, they're legally considered joint owners. And under U.S. law, that means each owner has full, independent rights to the entire patent. That includes the right to license it, sell it, use it, or commercialize it, all without the other's permission. They don't even have to tell you, and they definitely don't have to split the money. Worse, if you want to sue someone for patent infringement, you can't do it without the other co-owner joining in. One holdout, and you're stuck watching your rights go unenforced. Let's bring this to life with a real case. Schering Corp v. Russell UCLAF. Schering and Russell co-owned a patent related to prostate cancer treatment. They even had a signed cooperation agreement saying that if either wanted to sue an infringer, the other would offer reasonable assistance. All sounds very reasonable until Schering sued a company named Zeneca for infringement, only to discover that Russell had quietly granted Zeneca a license to the patent. And under joint ownership law, that license was perfectly valid. Schering's entire lawsuit crumbled. They argued that Russell had violated their agreement, but the court said that unless the agreement specifically restricted Russell from licensing, there was no breach of patent law, just maybe a breach of contract. So Schering didn't get to enforce his patent, and Russell's license to a competitor stood strong. Now here's a scenario that catches a lot of people off guard. Let's say your co-owner sells their share of the patent to someone else, maybe someone you don't even want to work with. Guess what? You now co-own a patent with them, and there's nothing in patent law that stops that sale, even if you had an agreement that said that they couldn't assign without your permission. That agreement might be enforceable under contract law, meaning you can sue your former co-owner for breaching your deal, but it doesn't undo the assignment. The new person still legally owns the patent with you. You just get the joy of litigating that after the fact. Now, you can try to protect yourself with tools like reversion clauses or conditional assignments. These tools can work, but here's the reality. They require tight contract drafting, and even then, you might still need to litigate to enforce them. And courts don't always love automatic reversions unless they're crystal clear. So while these are useful backup plans, the best strategy is to avoid uncontrolled joint ownership entirely in the first place. Now, you might be thinking, that's fine for them, but I trust my co-inventor. And hey, maybe you do. But relationships change, people leave companies, startups pivot, and when that happens, joint ownership can quickly become a liability. Here's why. 1. Licensing confusion. Your co-owner can license the patent without your input, even to your competitor. 2. Enforcement paralysis. You can't sue infringers unless everyone agrees. One silent partner, no lawsuit. 3. No revenue sharing rules. Your co-owner can profit off the patent without giving you a cent. And 4, investor aversion. Venture capitalists and acquirers don't like murky ownership. It creates friction, delays, and valuation headaches. Now, there are smarter ways to handle multi-inventor scenarios. Here are a few of my go-to recommendations. Get assignments up front. If there are multiple inventors, assign everything to one entity, like a company. This consolidates rights and avoids conflicts later. Use clear collaboration agreements. If you're working with external partners, contractors, or consultants, get it in writing. Spell out who owns what and how the patent rights will be handled. Draft a joint ownership agreement. If joint ownership is unavoidable, this is your next best step. You can limit each owner's ability to license or sell it, require consent for enforcement, and define revenue sharing. and assign to a neutral holding entity. For long-term projects or multiple contributors, consider assigning the patent to an LLC or other jointly owned entity with bylaws that govern decision-making. The goal here is to keep control of your patent clear and centralized, not fractured across people who may not share your business goals. So if you're developing something valuable, get ahead of it, assign the rights, structure your agreements, and don't leave things to chance, because once it's on paper and publicly recorded, the law doesn't care how friendly you used to be. Thanks for listening to the Patenting for Inventors podcast. If you need help navigating intellectual property, such as patents, trademarks, copyrights, or business matters, give me a call at 424-281-0162. Until next time, I'm Adam Diament, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diament directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.